7:30 where I'm at. I'm out in Palm Springs, California this weekend. It's convenient timing. The judge issued a ruling. I was on an airplane by the time I got through our 4.5 hour flight and landed in California and turned my phone back on. It was, everybody was looking for me, and I was on a plane, so what's the chances of that happening? But anyway, we've got the judge's ruling yesterday on the TRO. I spent a little bit of time. We didn't actually get to where we're at here in Palm Springs until almost 11:30, 12 o'clock. So it was really too late to do a whole lot at that point in time. And so I got up this morning. I read the order in detail and was reading. And there's a lot of questions, and I get that. And these things aren't easy. So I'll do the best I can to explain them to you. And I realize it won't answer everybody's questions, but I'll do what I can. So the judge granted the restraining order against the school districts that are named in the case. Okay. She did not certify the class, however, and let me explain to you what that means legally, very technically, but what it means practically is a whole lot less significant. Okay. So before I talk about those details, I'm hoping you guys, if you had a chance to read the order and read it close, before I even get to that, sorry, there's a lot on my mind, and so I won't be near as fluent in what I say today, I'm certain, as I often try to be. But before I get to that, let's talk about our honorable governor for a second, who's a licensed attorney in the state of Illinois. And again, he makes fun of me, and that's okay. But you know what? That just means I don't have to necessarily be deferential to him. Why is it when a judge makes a decision that he agrees with, he goes all about pounding his chest and proclaiming how learned that judge is and how they upheld the law? And it takes somebody like me. If a judge disagrees, I'm like, I respectfully disagree, and I still believe what I believe the law thinks, which is what a professional does. So Judge Grishow entered a very thorough ruling, and we'll talk about it in a second. It took her 2 weeks to do it. And, she didn't grant the class action. I understand her reasoning for it. I'm not going to disrespect her for it. Governor Pritzker then goes about and says what she did was misguided. He starts attacking the judge. Not only is that unethical as a licensed attorney to attack a judge and say you're misguided publicly, it's narcissistic. Why would you do that? You disagree? Okay, I respectfully disagree, and I will seek an appeal. Not that her ruling was misguided. You know what? It infuriates me that man has no candor whatsoever. But you know what? What would we expect from trust fund baby tyrant? So now let's talk about the ruling. Enough of that guy. Let's talk about the ruling. 29-page ruling, right? Granting the TRO. Granting the TRO, what she says is that these school districts cannot rely upon the governor's executive orders, can't rely upon ISB's guidance, can't rely upon IDPH joint guidance with ISB, can't rely upon IDPH emergency rules, can't rely upon ISB, and the school districts cannot rely upon their own inherent authority to mandate masks on children or students, or children or staff. And you cannot exclude children without following the law. And you can't require vaccination or testing of, she says staff. Is she referring only to teachers? I don't think so, even though that's how we pled the case for the most part. She says staff. Those issues will have to be ferreted out. But she says that all of those issues, people have due process under the law, which is what I've been arguing since March of 2020. I've been arguing the same thing since March of 2020. My arguments have never changed. But here we are now with Judge Grishow, who disagreed with me for her own good reasons a year and a half ago, now finds herself calling the actions of the governor in these agencies the type of evil that the law was intended to refute. And she's right. She also goes on to say, which I thought was important, that what they were doing, the governor and his agencies, was a workaround to the court's involvement into the rule of law. I agree with her. She also said that they were trying to pass the buck on to the local school districts and make them the bad guys, which I agree with her. We all knew, anybody that watched those hearings knew what was going on, right? It was plainly obvious, the games they were playing and the rule of law that they were ignoring, because as Ms. Haggard said, well, if we give people due process, then the system might break down. Well, that's not a reason to disregard the law, okay? So, you guys saw the footnotes. You're asking me about the footnotes that the judge had entered. Let's talk about those for a second. Even though the judge denied the class certification and her TRO as it exists today technically only applies to the students and to the teachers listed. It's not as big a deal as you would think. I'll get to that. She says that she is finding that the governor, nor ISB, nor IDPH, nor the school districts have any authority under the law to mandate masks, to exclude kids, or to require vaccination or testing without giving due process under the law. She says that unequivocally, that is her finding in her order. So when she puts in those footnotes that school districts should conduct themselves accordingly, what she's saying to them is that even though this order, this injunction may not directly apply to you, I'm still saying what you're doing, if you choose to continue voluntarily, it's illegal. Does that make sense? I want you guys to understand it's the most important thing I've got to say to you today. The TRO that she granted, technically, from an enforcement perspective, only applies to the named plaintiffs today. But her ruling, her lawful ruling that she issued, is still telling school districts, you can't do what you're doing. You know, it's illegal. So each and every one of your school districts is right now, when you get these letters that we're looking at this, here's what they're having. Here's the conversation that they're having. Is that, yeah, this order, even let me be clear, even school districts that aren't named in this lawsuit. This is not just, for the 146 districts in the case. This is for every public and private school district in the state, what they're thinking right now because of this ruling. Are we going to continue to require this stuff in our school district, even though this order doesn't say that we're banned from doing so? Because what we're doing is illegal according to this judge. And so if school districts on Monday or Tuesday, as long as this order is in place, continue to enforce these rules, they're doing so knowingly that it's been found on a mass scale to be unlawful. And that could expose each and every school district. You've heard your school districts talking for months about, our liability. It was all based on conjecture. Not starting Monday, it's not, because there could be significant liability for school districts to continue to implement and enforce requirements that this court has said violates due process of law. And so every one of your school districts, again, regardless of whether they're in the case or not, regardless as it applies to children that may not be covered under a class certification or staff, they have to ask themselves, those school districts, are we going to continue with this illegal rule enforcement? Because if we do, we could end up getting sued by thousands and tens and hundreds of thousands of parents in civil rights violation claims. That's the risk they need to be concerned about. Hope that makes sense to you guys, okay? That's the most important thing that I have to say. Now, the injunction that she issued itself, the injunction prohibits the districts from taking any action against the named plaintiffs in the case. Okay, the named plaintiffs. If you are a named plaintiff in the case, and that's what it means today. A month, 2 months. I know that's a long time. I get it. Could that change? It could. All the judge said when she denied the class is that it was premature. Okay, again, I'm going to respect that decision. I don't think it matters in the long run. But the ruling, so if one of the named plaintiffs in these cases, if the school actually tries to make them wear a mask, it makes that exclude them from school without giving due process, or tries to vaccinate or test or mask an educator that's named, that's contempt of court. And then I, on behalf of my clients, can say, Judge, I'm bringing this school district the superintendent, the board, a principal, I'm bringing them in front of you to have them held in contempt because they did what you told them they could not do in this order. That's what that order means right now, okay? But again, as I've told you, I'm going to say it again. Beyond that, if you're in one of these school districts but not a named plaintiff with you or your children, or if you're in a district that doesn't even exist in this case, you still can go in there and say, you know what? The judge said it's illegal for all of you to be doing this. Are you going to keep engaging in illegal behavior? Because if you do, I'm putting you on notice. That's what you can do. And I would, again, suggest you're rightfully within your legal rights to do so. Now, as far as the case itself, there is going to be a process. If people say, we understand what you're saying, Tom, but we want to do what we can to try to fall under a named plaintiff in this case, if you're in one of the 140 some or 60 school districts, you want to be a named, we could potentially, you could do that on your own. There's a way to join the case. It's called a motion for joinder. You can do that yourself. You could hire any lawyer you wanted to seek to join that. We may try to create a process within our firm that gives people the ability to seek joinder. Because again, if you seek joinder into the case, then the temporary restraining order would personally protect you, if that makes sense. Okay, that process would take some time to get that person added. I don't know how we would do that yet, but we can talk about that. It's not for this moment right now, okay? So, TRO was granted. As to the named plaintiffs, starting Monday, the order, the mask order, the exclusion order, the vaccination or testing order, the named plaintiffs in both the teacher case and the parent case, they cannot do it, okay? And on the bigger question is how are they going to treat everybody else? Because they're going to be violating people's rights. I may not be able to drag them in front of the court under an injunction, but they're still violating people's rights just the same, and they know that. And all of you need to make sure they know that. If you are not named in these cases, you're a teacher or a staff member of a school anywhere in the state of Illinois, or you're a parent with children, you need to email all of your board members and your administration going, you know what, I may not be in this case, but this judge says that what you're doing is illegal. You need to stop it, and you need to stop it right now, or I'm telling you, I'm going to go get my own lawyer. That's what school districts are worried about right now. They're worried about not the class certification or not. They're worried about the order that she wrote was so direct and so broad that she said, school districts, conduct yourselves accordingly. And again, you can interpret that to mean you better decide whether you want to keep engaging in these illegal rule enforcement mechanisms. That's what she was telling them. I guarantee you that's what she's telling them. So that's the answer that I got for you guys. Like I said, the details, you can read those details for yourself. The ruling has tons of information in there where she goes after the governor and his agencies. And she should have went after them. I mean, it's, for goodness sakes, it's been almost 2 years now, and everything that they've been doing of recent is just political gamesmanship, trying to use the executive branch as the sole basis of governing. That's what the judge said, and everybody knows that that's what's going on, okay? So I'm going to take a few questions, and Ryan, if you see any in there that you think I ought to answer, I'll try the best I can, but hopefully that explains it. Okay, the appeal. Yeah, let's talk about the appeal. That's a good question. So Governor Pritzker, of course he's going to appeal, right? Because he issues his I'm glad you asked that question. Who asked that question? I want to make sure to point him out. Where did it go? I lost it. Things are rolling through here so fast. But Melissa asked it. Good question, Melissa. Thanks, Ryan. Of course he's going to appeal. Before the appeal, let's talk about the press release. right? Because here's what the governor's trying to do this weekend. Here's what he's trying to do. He's trying to change the narrative, right? He's trying to control the messaging from the bully pulpit. Oh, we're going to seek an immediate appeal. Oh, go ahead, Governor. That's fine. You have a right to appeal. You don't get on and start pounding your chest. You're going to appeal this misguided decision. He's trying to scare you guys, and he's trying to scare your school districts, because the governor knows that starting next week, if school districts just say, we're not going to keep doing these illegal rules and get sued by tens and hundreds of thousands of parents and be subjected to exponential financial damages, we're going to stop all of this nonsense. That's what he's worried about. So he's trying to say there's an appeal. Of course he can appeal, right? That appeal is going to take 2 weeks, probably, right? A couple of weeks. There's no stay of her decision. Her decision is in full force and effect. Would there ever be a stay or not? I don't know. We can find out later, but as of today, there's not. There's no hearing set on a request for a stay. I got emailed a copy of one yesterday asking the court for one. I've not had a chance to read it. I've not responded to it. It's not been set for hearing. And so there is no stay, right? You guys are going to roll into school absent some extraordinary circumstances that I can't even fathom. You roll into school on Monday. These school districts are in the position they're in right now of, are we going to keep using illegal rules? Or are we going to not? Because the rules are illegal. They're all illegal. The governor's executive order is invalid because he doesn't have the authority. The rules issued by these agencies are void and illegal. That's the main thing to take away. And so I'm going to keep repeating it. So while the judge's ruling says you can't enforce these illegal rules against the named plaintiffs in the case, are school districts going to keep enforcing illegal rules against people that aren't named in the case? I wouldn't. If I'm the school district's attorney, and I'm not any school district's lawyer in any of these cases, but if I was, I'd be saying, I don't know that you should enforce any of this stuff against any student, because if the judge is saying it's all void and to conduct yourselves accordingly, I wouldn't want to put myself in that position if I was a school district. But again, they got their own lawyers. They'll figure out what they want to do. Okay. Is the TRO only for 30 days? Temporary restraining orders. There was some lady from up in Christian County. I don't know, her last name's Craig or something like that. She's an idiot. And she said something, oh, it's only good for 30 days. You don't even know what she's talking about. Stick to cleaning teeth and not to talking about legal matters that are beyond your intellectual capacity. But 30 days, any TRO is only issued for that length of time. They can't issue them any longer, okay? What you do is before the TRO expires, you go back, you have another hearing with the judge. It's not even a complicated hearing. It's set for status, and the judge, unless there's been some complete change of circumstances, the TRO gets continued and stays in effect until the case ends. So because it's only good for 30 days is not an issue. It's not like in 30 days it's over, guys. It doesn't work that way. It's just from a procedural civil procedure matter of our rules of how we operate in courtrooms. It only lasts for 30 days, but then it gets extended and extended. Again, absent some change of circumstance, that won't happen. I mean, if the appellate court of our state, of the Fourth Appellate Court, would end up saying that they disagreed with Judge Grishow's decision, could that implicate it? It could. That's really the issue. But her opinion's pretty well reasoned, you guys. It's very thorough. It's very well reasoned. I never try to predict, but I believe the governor has an uphill battle on trying to get the Fourth Appellate Circuit of Illinois to overturn this ruling. I think it's a huge uphill battle. So for him to go out there and issue press releases of this misguided decision, blah, 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 it's just him trying to rattle the cage and to change the narrative, as I said. I think the opinion's well written. It's well reasoned. And again, I think it's an uphill battle for the governor to get it overturned on appeal. But, again, I don't try to predict what judges will do. But let me say this, regardless of any of that, guys, this ruling, you know what it 100% tells you that's unequivocal that no appellate court could ever change? Is that there's a conversation to be had And this is really one of the big parts of what we're dealing with. These school districts, all 820, 30 of them public and so many private. You know what they're thinking right now? You know what conversations are happening with these school districts of, oh, the emperor has no clothes. Maybe the governor's not all powerful, right? Maybe that's a conversation that we as people have. The governor's been scaring everybody to death for years, right? Scaring them to death like a tyrant, wanting to come down on them. That conversation's changing. And there's nothing that can take us back from that, right? That's the most important thing. The conversation's changing. You guys saw Timothy Christian School, the private school up in the north of our state that came out several months ago and said, we're going to have our kids being mask optional several months ago. And the governor and ISB came down hammering on them, and they got intimidated and they went back to mask required. They just sent out an email or a message last night to all their parents. Immediately starting Monday, we're going mask optional. You know why they did that? Because they have confidence based upon the judge's ruling, right? That there's a conversation to be had here about the lawfulness of what's going on here. And if enough of our school districts will do that, to say, you know what, we're going to stand up now because we don't think this is right. All the appellate courts in the world can't change the power of the people when they decide to move in a direction. It just doesn't work that way. The people are in control. They've always been in control. They decide what's right or wrong. Okay. Courts, they have a significant involvement in that one that I'm a part of and I respect. But ultimately, the people decide what's right and what's wrong. Okay, hope that explains the appeal process and the 30-day issue. Neither one of them are going to change anything, you guys. At least in the short term here. Let me see here. I know you guys are, I can't keep up, guys. I apologize. Ryan, if you see something in there, go ahead. No mass at sports or IHSA either. Well, guys, I don't know if you're, thank you, Amanda. I don't know if you guys are aware, but the IHSA changed their rules sometimes back. And, you know, they were saying that if a school, let me say, if a school district was on probation or something, that they couldn't participate. So that's all gone now. But what this means is that any school district, you know, named on school property at all, whether you're in a sporting event or what, if you're on that school's property, you cannot require these things. Whether you're giving them an education in the classroom, whether you're at an event, you know, in the gym after hour. I mean, for the most part, nobody's wearing them in the extracurricular activities anyway, at least in my part of the world. Maybe where you guys live in the northern part of the state, they're a little more picky. But again, as to the school districts listed, at least as to those named plaintiffs for now, it's where it applies. But are they going to keep making people wear masks at these events and stuff? That's the big question that I just explained to you guys all along. And they're going to have to figure that out. And I think they're taking a risk if they continue to do so. Will this help our private schools? Guys, again, private schools aren't named here, but the analysis and the court's opinion applies across the board, right? For the most part. So, you know, private schools, they can do what they want. Let me say this, any private school that has been telling their people that we must do this because of the governor, they don't have an excuse anymore, right? Now, you know, the court's ruling does not say that private schools are breaking the law because we didn't have private schools in this case. So that's different. But most private schools have been saying, oh, we got to follow this guidance. We got to follow this executive order. Go back to them now and say what else you got, because that's obviously not the case. So Pritzker can't force anybody to go. Let's talk about that, the remote learning. I did a whole session on that. Pritzker can't force anybody to go remote. Can he tell Dr. Is it Ayala? I think, yeah, Dr. Ayala that school districts need to go remote? Is he going to try to punish parents? They can try. I mean, I'll sue them again. That's in some fashion. But as it relates to remote, you've got your local school districts trying to say, well, us as the local school district in conjunction with the local health department, they can't do that. They don't have that authority. The authority to potentially go remote lies only with the superintendent of our state, which is Dr. Ayala. But to the extent she would try to do this in some arbitrary fashion to punish non-mask wearing, I think that would be found to be unlawful too. Because again, there's no reason they can't do that merely as to try to invoke some mass exclusion because you're not wearing masks. So again, we'll just have to wait what we see. But the governor's already put himself in a position where it's almost impossible to get reelected in the state of Illinois, in my humble opinion. Is he going to go try to put everybody on a remote because of this judge's ruling? I mean, that would be the nail in the proverbial coffin, in my humble opinion. Somebody's asking about returning to work. Guys, this has nothing to do with returning to work. Those specific people have given me these individual fact patterns. They're so specific. This case is what it is. It's about masking. It's about exclusion. It's about vaccination and testing, right? People that have been terminated in the past, whether they can go back to work or not, this case doesn't cover that. But I will say to you that, let's say, Judge Grishow, in my opinion, her ruling is going to stand the test of the appellate court. So let's say that it does, and everything that's been done to, let's talk about educators for a while, has been deemed unlawful. Because right now, Judge Grishow says that whole vaccination and testing scheme, unlawful. Let's say that remains. I think that's a good reason for a lot of people to have wrongful termination cases against their schools, right? So as for you that it's already happened to, it's one part of the conversation. It's also a part of the conversation for starting on Monday, whether school districts are going to continue with that vaccination policy. They're going to continue with that? Going to find out, right? But there's all kinds of potential conversations for a later date about wrongful termination and violation of people's civil rights. I mean, that is a huge, and that's one of the things I've always been concerned about in the long run for exposure to our state, because who's going to pay for those costs? The taxpayers, and that's okay. I'll increase my taxes to right all the wrongs we've done to people. I'm okay with that. But those are conversations for these school districts. Are we going to hire these people back? We're going to give them back pay. We're going to give them payment for their time that we force them off. They should have those conversations, but I can't answer those for you today. Seriously, somebody's going to ask me, I can't go to a store and refuse to mask. I mean, I'm sorry, with all due respect, if I'm going to point that question out because it frustrates me. It's like, who listening to this thinks this has anything to do with school or with other than schools? Come on, guys. I'm not it. Please don't. Everyone just blocked Todd. Okay, block Todd, Lily. That's fine. I don't know who Todd is. Call me a grifter. The Reckless Roadshow snake oil salesman grifter. How's that sound now, Governor? Oh, there we go. Who said that? Who's that? Neil? Neil. What would happen to the governor if he decides to extend his executive order? That's an interesting question. We'll find out. Right now, the judge has ruled that those executive orders, they don't have any, they can't, the governor doesn't have that authority, right? I mean, she made it clear. So there's an injunction that was entered, including against the governor, as it relates to Executive Order 18, which has to do with the masking. It expires today. Is he going to disregard her rule, her order? Because it's in full force and effect right now. Is he going to disregard that and extend an executive order that she says he didn't have the authority? We'll see, right? The governor's got to make that decision. Is he going to disrespect the court? Potentially be in contempt? He's got lawyers. He can figure out how to. But again, her ruling to me is pretty clear. That executive order is beyond his authority. There's an injunction entered as it relates to the enforceability and applicability of that executive order. Today, it's in effect. Going to completely ignore it and extend it? We'll see. Let me see. Here is Nathan. impressed of everyone getting involved. Nathan, that's the only reason that we're in the position we're in right now, my friend. It's because people decided to get involved. You know what hasn't changed between March of 2020 and February of 2022 as it relates to the issues we're talking about? The law. It hasn't changed. It's exactly the same. What's different today than then is hundreds of thousands of people like you saying we've had enough. Because I've told you guys all along, when the people have enough, doesn't matter. The legislature, the executive, and the judiciary work for the people. And the people decide what's right or wrong. We decide through our laws, through our actions. We decide. That's the only thing different. So you're right, Nathan. It's people's involvement. It changes everything. It changes the world. Let me think. Can we discuss discriminatory practice towards teachers and students that go maskless this coming week? Melissa, you always ask the good questions. I like it when you chime in because you always I can tell you're thinking, and I respect that. And that kind of goes, Melissa, with what I just talked to you about. Students that go maskless this coming week. So again, strictly with the order of what the judge has ruled. Any child listed in that lawsuit, right? And let me say this while I'm here, Melissa, because I'm not sure if you and I've discussed this. When we filed this case, there's up to 8 named plaintiffs on the case, right? Those are the only people I know. And sometimes there's less than 8, but there's no more than 8. And as far as who in the background was involved in that process, if people were trying to collect money in some fashion, that's none of my business. I don't have any involvement whatsoever, right? All I have is I have up to 8 people in each school district that are my clients. So if somebody gave you $20 to help bring this case and they're not named, they're not my client. I don't have any knowledge of any of that whatsoever, okay? Somebody sent me a message going, well, I paid $100 in some case or one of the districts. And I'm like, and I responded politely, said, I don't have any knowledge of any of that. I know who my clients are. I don't know if one of them paid it all or if they divided it equally or they did a GoFundMe. I don't know about any of that stuff, okay? So can we discuss discriminatory practices towards teachers and students that go maskless this coming week? Melissa asks. So on Monday, again, where we're at today, every child listed in every one of these districts can walk in the door with no mask on. And I have a restraining order that tells that school district you cannot do anything to that child. If you do, I will file what's called a rule to show cause, and I will have them brought in front of the judge on a contempt request. That's straightforward. Now, what about the children that aren't in the case on Monday? Let's say they walk into school without a mask on. The school district has a decision to make. Does my restraining order stop them from making that other child wear a mask? It does not today. But, and that is the biggest I can't do it backwards, the biggest but that I can say, but is that district going to make that child wear a mask after the judge has said what you're doing is unlawful? The governor, IDPH, ISB, you as a school district do not have the authority to do that. She said it. So even if that child is not named in the case, still doesn't mean that school district doesn't have that decision to make. The only difference between the 2 children in the example that I gave you, the only difference today is that if they can't make the child named in the case wear one without being subjected to a potential contempt request. However, as to that other child, they're still engaging in the same illegal behavior, which may subject them to further litigation in a variety of different capacities as to that other child, because they are going to be knowingly engaging in illegal behavior, according to this judge. Does that make sense, Melissa? I hope it does. So that's the discriminatory practice that these school districts right now are trying to figure out. Okay? Let me go on. Go ahead. I hope that answered it, Melissa. I think it does. If not, somebody can ask it again, and I'll keep saying it over and over, because that's the most important thing I need you to understand. No, as to the second case, somebody just asked about the second teacher or parent case. They weren't going to give us hearing on that case until after this one was over. Now that the judge has ruled, I'm going to get a hearing on that case, on parent case number 2, first thing Monday, and I will let you guys know. But for those of you in parent case number 2, it's the same thing that I'm saying to everyone else. Even though we haven't got the TRO in that case, seems likely we will now that she's ruled this way in the first one. Those school districts still are sitting there going, are we going to continue with this illegal action or not, regardless of the TRO, guys? All right. What about buses? Buses are buses are owned by the school district too. It's school district property. So if they put a mask on one of my kids on a school bus, I'm going to drag them in front of the court for contempt. The school bus is not governed by anything else other than Illinois law. This nonsense that the federal rule that was issued covers school buses is ridiculous. I can tell you in the TROs that I've had in the past, again, in the Hillsborough school and the Carlisle school, I can tell you that the lawyers for those school districts absolutely were of the opinion that they could not require them on masks as well, because masks are school property. And in my opinion, it's a violation of the restraining order. That federal rule, the short version is a bus in Bond County, Illinois, driving around picking up kids in Bond County, Illinois is not governed by federal jurisdiction, you guys. You can take that rule and throw it in the garbage. That was just a way your school was trying to use more fodder to intimidate you. But I can tell you, in my opinion, buses are no different than sitting in the classroom. So we'll leave it at that. I will answer that one. That's a fair question. It's a little outside the scope. What is that? Constantino? Where'd he go? Lost it. Is the judge's ruling extend to other, this is talking about municipal enforcing. The answer is no. It doesn't apply directly, Constantino, but practically, I think it does. And I will say this. As for other governing bodies, municipalities, things like county governments, things of that nature, and even for private businesses, I think they ought to take a good look at this order, because to the extent they were saying that they had to make people wear masks because of the governor's order and these state rulings, I think they can look at that now and say, we're not going to pay attention to that anymore. But the order doesn't directly apply to it, sir. Stephanie Rasner said, would it be beneficial to put the school on notice? I mean, again, I'm not really giving you legal advice. I can tell you it wouldn't hurt, just as a matter of courtesy. If you're a parent, and even if you're not listed in this case, or even if your district's not in this case, if you could say, look, I've read this order. The judge says that it's all unlawful, so we're going to be, having our kids come to school Monday with no mask on, and if you do something, we're going to take action. There's nothing wrong with being polite and letting them know ahead of time. So. Somebody asked about the specific list of named students. You will not have a list of named students. I think Betsy asked it, because children's names are not put in documents anywhere. If you look at the case, you'll see the parents that are listed, because they're the adults and it's their children that they ask to be covered. You will not see those children's names anywhere or disclosed in any public record. It's improper. Again, somebody asked it again, what about Joinder for people that contributed but are not named in the lawsuit? Carissa asked that question. And again, Carissa, I'm going to say it again. If people contributed and are not named in the lawsuit, I have no knowledge of any of that. That had nothing to do with me. I have a list of clients that hired me and paid me. Where that money come from, I have no idea. To the extent people want to join this lawsuit and seek to, Joinder that I talked about earlier, I may offer an opportunity of somehow figuring out how to put a mechanism in place for people to join. Other lawyers can help you join. You can do it on your own. But to the extent somebody contributed to one of these cases that the people named in, that somehow they would believe that means that it obligates our law firm to help them join. That's not the case. And I apologize if you feel it should be. But again, I have no knowledge of who in the background did any of that. I only know I've got up to 8 clients in each school district, and they paid me. Where that money come from is none of my business. Are people still able to join lawsuit number 2? Again, that lawsuit's already been filed, so to the extent new school districts wanted to be added, not to that case, but if there are parent groups that potentially want to do new cases against new school districts, I'll put something out on that a little bit later, guys, and we can discuss it later, okay? Mark Clark says something about starting over in Quincy. I don't know what he's talking about. I think, again, you guys need to, you have to talk, you and Ronnie are talking, you guys talk about that yourself. What happens when they file an appeal? Nothing. They file their appeal, and we've got 2 days to respond from the time they file their appeal. The appellate court will take up to probably 10 days, so it's a couple weeks out. Yeah, all the stuff I'm reading now is people that must have joined late, and they're asking the same questions over and over that I've already answered 2 or 3 times. I'm not going to answer those questions. This has got nothing to do with colleges. But again, colleges, their boards can read that too and read the analysis of the judge, make their own decisions. Again, any body of government out there that's been telling people we don't have a choice, the governor's executive order says we have to do this, ISB or IDPH says we have to do this because of their emergency rules. Any public body or private business that's relying upon that, they need to find a different scapegoat for you now, because you can go back and say that doesn't work anymore. Okay. Somebody blocked Todd again. Poor Todd. Let me see here. Yeah, Lisa, that's a good question. We put that petition out just to start gathering names of people that might be interested in Joinder. You know, I have that list of people. And again, I will be talking about how we might be able to put something together that offers the opportunity to join. I mean, there's a motion that has to be filed. There's a hearing that people have to go to join. So again, we're going to look at that. But right now, again, it's the weekend and I don't have time to get to it, maybe tomorrow or Monday. But yeah, I have the list, and the list was for letting people know that we may do something. Lily, my son wants a shirt with your face on it to wear to school. I'm not very photogenic, dear, but to the extent you want to pilfer one off of the internet and wear it, I'm flattered. But yeah, I would ask him to find, go get Brad Pitt or somebody a little bit more better looking. Okay, somebody's asking, I'll go ahead and do this, guys. That's fine. About the legal quarantine. What's that mean? And the test to stay and all that nonsense. I mean, let me help you with that, okay? Oh, give me a second. The law. What does it say? Okay. Where can we get Thomas DeVore grifter merch? Sorry about that. I'll answer your question. How funny. What's the law say? Putting a mask on a citizen. Putting a mask on because we need to protect the public from them being a potential spreader of an infectious disease. Vaccinating or testing someone, a citizen, because we think we need to do it to prevent the spread of an infectious disease. Excluding a child from school for some amount of time because we think we need to prevent the spread of an infectious disease. All of those issues can be accomplished under the law as it exists right now. It's in there. But you get due process as a citizen under the law to object that it's not necessary to do any of those things to you in order to prevent the spread of an infectious disease, right? Doesn't that just make sense? I mean, I'm okay with the law saying that under some circumstances we may need to do these things. But the law protects everybody to say, no, I don't want you to do that to me. Okay, that's what the law says in English. So let's say that let's talk about exclusion from school. That's one of the easiest ones of a student. A child tests positive at school. And they go through right now and they do their little in-house, check. And, little Johnny was within 5 or 6 feet and little Susie. So you get the call as a parent. And they say, oh, yeah, you're close contact. You got to go home. Kid got to go home for X amount of days. Well, we might let you test to stay. And they want to start just feeding you all of these rules about what you have to do. And you have to like it, right? That's what the judge says. No, it's not what the law says. Now, let me tell you how it works. The kid tests positive at school. Let's say your child sits next to them. You will get a call from the health department, not the school district, not the superintendent, not the school nurse, the health department of your county will call you and say, sir, ma'am, your daughter such and such, they were a close contact with a child at school, so we're asking you to exclude them for some amount of time. That's what they're going to ask you. And you're going to say, well, who are they a close contact to? Now, they'll want to say, oh, we can't tell you any of that. It's privileged and blah, blah, blah. But you as a parent are really struggling with, maybe I should keep my child home for a while because you don't want to spread this infection. You don't want to do that at all. But they won't give you any information. You say to them, I'm sorry, I do not agree. You need to get a court order. Health department has a choice right then. Let it go or issue an emergency or an immediate order of quarantine. If they issue the immediate order of quarantine, that is the force and effect of law. Your child would not be able to go to school during that 48-hour period because the school district is right to exclude your child if the health department has issued a lawful order. Within 48 hours, they then have to take you to court in front of the judge, and they have to convince the judge with facts, specific facts, your child should be excluded. And that not only should your child be excluded, that they should have to then go through the test to stay, etc. All of that test to stay and everything only matters if you agree to it or if the judge orders it. So you could go have a hearing with a judge and he could say, yeah, I think your child might have been in close contact. And so they can only go back to school if they test to stay, do these things. Those things only matter if the judge orders it, okay? So once you decide as a parent, I'm objecting, they can't keep your kid out of school unless they test to stay or do this. Only the judge can order that stuff, okay? So that's how it works. Same thing with a mask. Your child walks in the door without the mask on, under how the law works. Before they can tell a child to put on a mask, they have to get the parent to consent or convince a judge that that child needs to wear a mask in order to not spread a disease. They just can't make you do it. So that's how the law works. The health department can issue an emergency order that's good for 48 hours, that if it's done properly is lawful, but then they have to take you to court, okay? And people that get these emergency or immediate orders, they have the right to an attorney. That's what's nice. If you get that order from the health department and you can't afford a lawyer, they have to appoint you one, free. That's why it's such a big deal, because they're limiting your rights of freedom of movement as a citizen, either you or your child. You have a lot of rights. You have a right to a lawyer. You have a right to be heard in front of a judge, etc. And that's what the governor and all these agencies were trying to take away from all of you, and the judge said no.
Hey, Tom, we're going to take a quick commercial break to give you a thank you. I know on my behalf and all the other parent groups with Shannon and everyone else, we all wanted to formally say thank you. So we're going to share this with everybody.
My pleasure, sir. Oh, you got to play something?
In a video released on social media, Pritzker touted his handling of the COVID-19 pandemic.
These lawsuits have been working against people's health and safety. You know, he has seemingly been collecting money from people grifting all over the state to file lawsuits that shouldn't have been filed. You know, we should be working together, all of us, to try to get past this pandemic. Nobody wants to wear masks. I don't want to wear them.
But again, if the judge in fact rules that none of those government bodies, including the school district, has the authority to mandate masks, or they can do exclusion of school without complying with the Department of Health Act, then school districts wouldn't be able to engage in that in making rules as it relates to those specific issues.
Thank you on behalf of all of us, and we appreciate all that you did for all the parents and all the student groups.
Thank you. Appreciate that, sir. You know, I hadn't listened to that yet, but I was listening to the governor's words. You know what he doesn't say? Because he says he's trying to keep people safe. Let's say that he means that. You don't keep people safe from a virus by taking away their liberties and rights guaranteed to them by the Constitution and law. That's not keeping people safe. That's making them less safe. If he believed for a moment that what he was doing was necessary to keep people safe, he would have convened the General Assembly and let the people's branch of government pass laws that afforded him or the agencies to create what he was trying to create. That's what he would have done. And to that extent, I would have been okay. I mean, I like it, but I'll respect it. He's trying to suggest that these lawsuits were making people less safe. The harms that we as people face from allowing an executive officer to run our state like a tyrant is exponentially more risky than dealing with a virus, especially one with a 99-point-something% survival rate. But that fact doesn't really matter. The governor doesn't get that, you guys. He doesn't get that. He thinks that people being afforded due process of law is not as great a risk as wearing a mask. It unbelievable that he would even say that. But again, I guess if I was in his position and a trust fund billionaire that never had to want or do anything in my life or ever be told no. I mean, you think he's ever been told no in his life? Probably not. I mean, maybe I would think that way if I was in his shoes too. But for looking from my vantage point of just a poor guy from the streets that worked his way up, everything he says I find abhorrent when it comes to that. You know, separation of powers and due process of law never yields, ever. And if it's ever going to yield, the legislature and the people decide when to yield, not an executive officer. And if he doesn't understand that, I hope he never wins another election in his life. Let me see here. I'm proud to be a grifter. Let me see here. Ryan, you see any more questions, buddy?
No, you've covered most of them, Tom. I'm sure they're going to come up as it comes on, and we know you got you're out of town, and we appreciate you taking your time today to explain this to all of us, and we want you to enjoy your time away and take some time to decompress. So everyone, Tom may not be readily available all the time, but he enjoys the time to decompress this weekend.
All right, I'll be in touch. You and I will talk about the other part, okay?
Yep, sounds great.
All right, have a good day, sir.
Thanks.
Thank you, everybody. Take